This meeting is being recorded.
Thank you. Hello, my name is Josh Blackman, and I am the president of the Harlan Institute. It's my honor to welcome you to the 2021 Virtual Supreme Court competition. This year, we're arguing the case of New York State Rifle and Pistol Club versus Bruin. Today, we're having match number 3 of the semifinal round. From Bret Harte Union in Murphy, California, we have Miss Lewis. And from Dublin Christian Academy in New Hampshire, we have Miss Figueredo. Petitioner, you may begin. 10 minutes whenever you're ready. Go ahead.
Thank you, Mr. Chief Justice, and may I please the court. New York's licensing officer denied my law-abiding clients their Second Amendment rights by denying an unrestricted license to carry firearms outside the home for self-defense. The question before this court is if New York's denial of the petitioner's applications for concealed carry licenses for self-defense violated the Second Amendment. New York's statute is unconstitutional for at least 2 reasons. 1, the statute is inconsistent with the text, history, and tradition of the Second Amendment. 2, the statute gives too much discretion to the licensing officer. To begin, the statute violates the fundamental and individual right to bear arms on the basis of both text, history, and tradition. The Second Amendment provides the right of the people to both keep and to bear arms. No provision of the Constitution can be considered superfluous. Therefore, this court must rule with consideration of each word in the operative clause of the Second Amendment.
What do keep and bear mean under the Second Amendment?
Under the Second Amendment, keep and bear determine the words that are used for the Second Amendment. In D.C. v. Heller cited Johnson's Dictionary, which defines keep and bear as keep means to carry, and to bear, if I look, is the same as saying to convey or carry, and keep means to have, really. So when we are looking at those terms, those are the most important parts of the text, history, and tradition, because the text of the Second Amendment shows what the framers really meant when we look back to there.
Let's talk about Heller. If I can, Counsel, if I can interrupt for a second, I'm sorry. Let's go back to Heller for a minute. Did Heller resolve the question of whether there's a Second Amendment right outside the home? Did Heller resolve that issue?
Well, Your Honor, Heller did not technically resolve the Second Amendment question that to carry arms outside the home is part of the Constitution on that aspect. However, the question presented in Heller was that to keep arms was being prohibited in this sake, because Heller was based off of only the question of is the limit on keeping an arm constitutional. In this case,
Counselor, is there any language in Heller that you think is important to your case that would help us decide the New York case?
Yes, Your Honor, there is certain language in Heller that is very important. Heller describes the operative clause and the prefatory clause. The prefatory clause is the beginning, which was always considered to be part of the militia as the Second Amendment. However,
but the prefatory clause goes to what the right means. But I'm talking about specifically, is there any language in Heller itself that concerns carrying outside the home?
Your Honor, there is little language in Heller itself that concerns carrying outside the home. However, Heller does describe that both verbs keep and to bear.
What about the discussion, Heller, of sensitive places? How does that affect our discussion?
Well, Your Honor, sensitive places are something that my clients do not wish to carry firearms outside of. Throughout other cases, there will be more definitions of the term sensitive places, but we have to look at that test that has to be created for that. In this case, we cannot use text, history, and tradition because the text of the Second Amendment says nothing about sensitive places, nor to my knowledge, the history
So
or the
is Heller inconsistent with the Second Amendment then? Because Heller said sensitive places. That's the opinion.
Heller is not inconsistent with the Second Amendment, Your Honor. Heller said sensitive places as the term for the text, history, and tradition, and that certain places can be restricted upon because they are at some sort of heightened risk, or even they provide obvious protection already. Heller is saying that those cases have to be decided throughout other cases. It cannot be decided within this one case, Your Honor.
Okay, Counsel, you may proceed.
The Second Amendment provides the right to both keep and to bear arms. No provision of the Constitution can be considered superfluous, like I already said. Therefore, this court cannot rule without consideration of each word in the operative clause of the Second Amendment. The operative clause in this case would be to bear. The history and tradition of the Second Amendment exhaustively establish the right guaranteed to bear arms is also linked to the right.
You state the word historical justifications in your brief a couple times. What is the most persuasive historical justification here for a Second Amendment violation?
The most persuasive historical justification, Your Honor, would be Samuel Johnson's dictionary. Samuel Johnson's dictionary provides that bear means to convey or carry. I'm using the dictionary from 1773, Your Honor. And this historical justification illuminates what the framers actually meant by the Second Amendment. History and tradition, those justifications are used to show what the Second Amendment meant by the framers instead of just applying history and tradition to the actual case, Your Honor. Back to my argument, history and tradition exhaustively establish the right guaranteed by the Second Amendment to bear is linked to the right to self-defense. Shortly after the ratification of the Second Amendment, at least 9 states adopted laws to protect the right to self-defense. For example, Kentucky, Ohio, Indiana, and Missouri even refer to that right as, to quote, bear arms in defense of themselves in the state.
So Counselor, I mean, New York doesn't ban concealed carry altogether, right? Maybe we can pivot to that point. They allow concealed carry if you show good cause. Why is the good cause standard inconsistent with the Second Amendment?
The good cause standard, Your Honor, is inconsistent with the Second Amendment because it provides discretion to the licensing officer. That discretion is seen because there's no definition or guide of a proper cause in the statute.
But there's lots of cases where government officials use discretion, right? Why is the fact that government officials using discretion violating the Second Amendment?
Well, Your Honor, the Second Amendment is an individual right. This court cannot use discretion to determine any right by the First Amendment. But
this is not random discretion, right? It's, do you have a good cause to exercise self-defense? Why isn't that enough? It's not, they're not flipping a coin, right? Well, why is this standard not sufficient?
Well, Your Honor, this standard provides a privilege to a citizen. The Second Amendment is not a privilege. It is an individual right. A privilege would be something like to drive, for example, where you have to have a guide of places to go to be able to drive. But an individual right that
But guns are dangerous, right? Guns can kill people. There are statistics, up to here about why this is going to be helpful to reduce deaths. I mean, do you want people to die?
Well, Your Honor, the petitioners in this case do not wish to carry arms for harming of others. The petitioners wish to carry firearms for self-defense so they cannot get hurt and they cannot die because somebody could attack them or something else, Your Honor.
Very good. Okay,
and
very good. You can proceed. Thank you.
Heller held the right to, back to my argument, Heller held the right to keep arms is an individual right for the purpose of self-defense, and the other compound verb to bear can also be included in this right. New York denied the applications of the unrestricted concealed carry firearm licenses to the petitioners because they did not show a, quote, proper cause requirement. This requirement does not include the right to self-defense. Petitioners who are law-abiding citizens and have no previous history of violence were denied their licenses. This amendment of the constitutional law does not leave room for an atypical need, such as a proper cause to a right like the right to self-defense. And then New York's licensing officer gets undue discretion, like we just previously talked about it as well.
Okay, thank you so much, Counselor. I appreciate it. Okay, we now have the respondent, and just please keep your camera because I think your your bandwidth is not the best. Okay, all right, Ms. Figueredo, you can begin whenever you're ready.
Mr. Chief Justice, and may it please the court, I am Gabriela Figueredo, and I am representing the respondents. In District of Columbia v. Heller, Heller says that the court should look at historical evidence when it comes to the Second Amendment and seeing if it is constitutional or not. History shows that New York's concealed carry permit doesn't go against the Constitution. We will be looking at British history and then some other recent U.S. cases. The purpose of the Second Amendment is for self-defense in the home, as held in District of Columbia v. Heller. The United States v. Miller case says that the purpose of the Second Amendment is for Congress to be able to equip the militia. The historical record shows that New York's special requirement for a concealed carry permit doesn't go against the Constitution. We will look at English law and American history and other cases. On page 2 of the brief of Professors of History and Law of the respondent explains that how in the Statute of Northampton there were restrictions for arms in 1328. And it says that no man shall come before the King's justice with force and arms, nor to ride armed by day and not by night, in fairs, markets, nor in presence of the justices or other ministers, nor in no part elsewhere. According to this quote, it clearly states that there was a regulation of arms depending on where someone went, specifically in public areas. This supports New York regulating arms in certain locations.
Counselor, if I could just interrupt you for a minute. We have this statute of Northampton, which you cited very eloquently. Appreciate that. But there's some debate about whether this statute applied only to those who are carrying weapons in a threatening or menacing manner. Do you have any response to how we should understand the statute of Northampton? Can you hear us? I'm sorry, I don't know if you didn't break up.
Your Honor, may you please repeat your question?
Yeah, I'm sorry, I'll repeat it. With the statute of Northampton, there's some discussion of whether it applied to carrying a gun at all or carrying a gun in a threatening manner. Do you have any thoughts on that issue?
Can you repeat the last part again? You cut out.
Do you have any thoughts on how we should understand the statute of Northampton?
Yeah, Your Honor. William Blackstone, he explained how the Statute of Northampton and he said that the offense of riding or going armed with dangerous or unusual weapons is a crime against the public peace by terrifying the good of the people of the land, and is particularly prohibited by the Statute of Northampton. So, Your Honor, this explains how the people that were terrifying the good people of the land were putting others in public in danger. So.
Okay, thank you so much. And I understand we're having some bandwidth issues, so I'll make sure my colleagues, Justice Wollaston or Grillo, do you have any questions?
No. No.
Justice Wallison?
Yes, I have a question. So in the petitioner's brief, she states that today 43 states allow people to carry firearms outside of their home. Why do you not think that New York should also join the majority of states?
May you repeat that, please?
Yes, so in the petitioner's brief, she states that today there's 43 states that allow carry outside of their homes. Why do you not think that New York should join the majority?
In District of Columbia versus Heller, Heller claims and it said that we should look at historical evidence to see if the court to see if the Second Amendment is constitutional or not, and to see if and what it protects. And seeing that with history, it shows that some places did, like in the Statute of Northampton, do requirements on banning arms. So, Your Honor, I believe that New York's regulation of arms isn't going against the Second Amendment.
So, Counselor, if I can ask you a question, what level of scrutiny should we follow after Heller? Did you hear the question?
May you repeat that, please?
What level of scrutiny should we follow after Heller?
The court, Your Honor, the court should use intermediate scrutiny. The court should consider public safety by regulating firearms. The court should look at early American history and early modern history.
Counselor, didn't the court in Heller use the term heightened scrutiny? Am I incorrect in that?
Your Honor, I am not sure.
You're not sure. Well, to the best of my knowledge, they use the word heightened scrutiny, and that's not really clear as to whether that means intermediate or strict scrutiny. Why should we apply intermediate scrutiny here?
Your Honor, we should apply intermediate scrutiny over strict scrutiny because strict scrutiny doesn't, for the Second Amendment, isn't necessary because it doesn't help the democracy work better. In fact, it can put the public in actual danger and public safety would be at risk.
Well, Counselor, let me ask you another question. Does the Second Amendment protect a right to bear arms outside the home? Does this right exist?
Your Honor, it does exist. In District of Columbia, that was held that can you guys hear me?
I'm really sorry. It keeps breaking out. We're going to do the best we can under the circumstances. So did Heller hold there was a right to bear arms outside the home? Did Heller make that holding?
Yes, Your Honor. The purpose of the Second Amendment is for self-defense in the home as held in District of Columbia.
But
versus Heller.
Heller was about in the home. My question was different. It's outside the home. Does this right extend outside the home?
No, it does not, Your Honor.
Okay, so there's no right outside the home.
Not that I'm aware of.
So under your interpretation of the Second Amendment, a state could wholesale ban the carry of firearms outside the home.
May you explain your question, please? I'm not really understanding, Your Honor.
If there is no right to carry outside the home, then New York could simply just ban firearms outside the home wholesale. Totally.
Your Honor, I believe as New York says, you need to have a good cause to be able to carry outside of the home.
You can continue with your argument, Counselor.
Right. It provides that Protestants may have armed their defense suitable to their conditions as allowed by law. The phrase as allowed by law states that it isn't an absolute right. So there are restrictions and limitations on some rights. An example of this we can see is the First Amendment. The freedom of speech does have limitations. If you were in a public place, such as a movie theater, and you yell fire, you would be terrifying the public and could cause danger among them. The Honorable Counsel for the Petitioners, she used Sir John Knight's case, and according to the professors of history and law, they state that on page 7, paragraph 2, that scholars use Sir Knight John's case to explain the Statute of Northampton. But this is badly interpreted. This case is badly interpreted, and it goes against what legal historians claimed happened. Like William Blackstone, he was a very important legal scholar in the 1600s. William also, he wrote the legal textbook. Many of the founding fathers probably read his work because they were mostly lawyers. And by reading William's work, they probably had been influenced by him and probably would understand the Statute of Northampton through his perspective. Blackstone, he contradicted the court's decision in Sir John Knight's case. Therefore, Sir John Knight's case isn't the best explanation for the Statute of Northampton. The purpose of the Second Amendment is for self-defense in the home as held in District of Columbia. United States v. Miller also says that the purpose of the Second Amendment is for Congress to equip the militia. In the late 1600s, New Hampshire, New York, and Massachusetts prohibited people from carrying of arms offensively in public areas. In this tradition, New York's law is constitutional because it follows historical precedents. The Court District of Columbia v. Heller held a regulation that mentally ill citizens could not get or apply for gun licenses. This was around the 1920s, therefore we should look at earlier and more recent historical evidences.
Counselor, should we put any weight in the fact that New York law was enacted in the early 20th century and there's a very strong anti-Catholic bias? Should that affect our analysis at all?
No, Your Honor, I don't think it should affect the...
Why? Why should it not affect our analysis?
As held in District of Columbia v. Heller, we need to look back at historical evidences to prove if the Second Amendment is constitutional or not. And by stating these court cases and looking through them very carefully, we can see that there isn't a problem for New York to be regulating arms.
All right. You proceed, Counselor.
The purpose of the Second Amendment is for self-defense in the home, is held in District of Columbia v. Heller. United States v. Miller states and says that the purpose of the Second Amendment is for Congress to equip the militia, and the court should use intermediate scrutiny. The court should also look and consider public safety by regulating firearms. The court should look at early American history and modern history as well. And the definitions of the verb keep means to hold and to retain in one's power or possession, not to lose or part with it, as to keep a home or a farm, to keep anything in the memory, mind, or heart, as said in Webster's Dictionary in 1828. And the definition of the verb bear means to carry, to convey, to support, and to remove from place to place as they bear him upon the shoulder, the eagle brethren, then them on the wings, as said in Webster's Dictionary in 1828. So the
Counselor,
same
if I
year
could
as
ask
the
one more
verb.
question. We're talking about, right, gun safety and gun policy. What role should the courts have in deciding statistics and gun safety policies. That's something for the courts to even think about.
Your Honor, may you repeat that, please? You cut out.
I'm sorry. What role should the courts play in interpreting statistics? Is this something that judges should be doing?
Your Honor, like District of Columbia versus Heller said, we should always we should look into historical evidence to prove if the Second Amendment is constitutional or not. In that case, we should just look and see, not through statistics, but just to see if if there's any interest in seeing if it's a compelling interest of the government.
Okay, thank you, Counselor. You have about 30 seconds left if you want to wrap up.
May you repeat that, please?
You have about 30 seconds left if you want to wrap up and give a summary.
Your Honor, the
right.
purpose of the Second Amendment.
Go ahead, you can finish.
The purpose of the Second Amendment overall is for the self-defense in the home, as held in District of Columbia versus Heller. United States versus Miller also says that the purpose of the Second Amendment is for the Congress to equip the militia. Therefore, New York's concealed carry license permit doesn't go against the Second Amendment.
Okay, thank you so much. All right, we have petitioner, please, for 5 minutes rebuttal.
Thank you. My friend on the other side's reliance on US v. Miller is misplaced. US v. Miller's holding was reversed by DC v. Heller, or really not reversed, but redefined by DC v. Heller. DC v. Heller defined US v. Miller as Miller stands only for the proposition that the Second Amendment right, whatever its nature, extends only to certain types of weapons, end quote. These weapons are weapons in common use. In this case, my clients wish simply to carry handguns, which are weapons in common use for self-defense, so they cannot be hurt by somebody else. They just simply want self-defense.
Counselor, I'd like you to respond to the argument that the respondent put forward that we have restrictions on First Amendment rights. Why can't we have these restrictions here?
Well, Your Honor, we do have restrictions on First Amendment rights. We have restrictions on First Amendment rights to a certain extent as well. First, the First Amendment restricts rights if they are in what would be considered in the Second Amendment sensitive places, in places that you want to be restricted to have rights, so then it could not, for example, skew voting rights. That's why there are certain restrictions at ballot offices that you cannot have campaign signs over a certain amount of feet. My clients do not wish to have firearms in sensitive places, which would be similar to having restrictions in the First Amendment. They simply wish to carry them in.
Counselor, if I can interrupt you, the subway, right? New York City has a subway. Would the subway be a sensitive place?
Well, Your Honor, the subway could be considered a sensitive place through the tests that could be found through many other cases. We cannot find this case today, Your Honor, because there's simply not enough statistics for that.
So you're okay with, what about a college campus?
Well, Your Honor, a college campus could be considered a sensitive place based off of the tests that could be found by other cases.
What about the entire island of Manhattan? The entire island of Manhattan, could that be a sensitive place?
Well, Your Honor, that is very broad for a sensitive place. The entire island of Manhattan is would not be considered a sensitive place, because if we look at the text of the Second Amendment, it says nothing about that. However,
But then why is a subway or a college campus? In other words, how do we know what a sensitive place is? I find these Manhattan's too much. Okay, fine, I'll take that, right? But how do we know, where do we draw the line? What tells us where should we draw the line and what a sensitive place is?
well, Your Honor, the limiting principle could hypothetically be found through other cases. We cannot find that limit today because we simply do not have enough information to find what the best sensitive place is.
So then why shouldn't we just rule against you? If we can't make a decision on what's sensitive place, why don't we just let the government decide and get the courts out of this business?
Well, Your Honor, the limits on the sensitive places are extremely strict in New York statute. For example, when Petitioner Nash was
Well,
denied.
I know they're strict. I mean, that's why you guys are in court, but then why should the court be deciding this? So maybe the right answer. We just let New York figure this out. Why? If you can't tell me what a sensitive place is, then how am I supposed to know? Then maybe the elected branch should decide this.
Well, a sensitive place has to be ruled throughout many other holdings based off of what this holding does through other courts. But a sensitive place could be considered any place that is of heightened risk or is of any other restrictions that could have something against them. The issue in this case is that it is severely strict. And in the Joint Appendix, I believe it's Joint Appendix 41, it quotes, this is the denial letter from the licensing officer, that the restrictions prohibit you from carrying concealed in any location typically open and frequented by the general public. These restrictions are extremely strict. The general public is not generally a sensitive place, as far as 43 other states have shown.
Okay, Kelsey, about 5 seconds left. Just want to wrap up.
Therefore, this court wishes to reverse the order by the trial court. Thank you.
Okay, thank you so much. Let's turn the timer off. All right, that was fantastic. I have to tell you, Gabriel, if you want to turn your camera back on so we can see you for a minute. Myself, Reed and Ashley, these are two law students at my college. We gave you some really hard questions. And what we were trying to do is to push you and to see how far you'd be willing to go. And you really rose to the challenge. I got asking, do you want people to die? Right? And you recovered, right? I'm asking at the Statute of Northampton, and you smoothly say, well, on paragraph 7 of this brief, and you have this stuff at your fingertips. That's not easy. I know we have technical difficulties too. I know it's not your fault, Gabriella. Please, I know that's not your fault. Sometimes the Zoom gods do not want to work on our side, as I'm sure any teacher would know. You guys are in person now, right? I think you are. Yeah, we're in person now too. Thank God. But we really appreciate it. You were both poised. You were both solo. I think you were the only two solo teams, which is why I think I paired you one to the other, so that'd be a little bit more fair. You couldn't sort of rely on your partner to bail you out. You had it all on you, and that's not easy. So it's really it's more than twice as much work because you have so much more responsibility. I really appreciated how you didn't crumble when I gave you a hard question. You sort of took the question. I could see in your face like, oh, at least I could see on Miss Lewis's face, like, oh my God. And then it's like, okay, whatever, I'm going to answer it. And then you pivot from a weakness to a strength, right? That's one of the most important skills you can learn as an attorney, to go from weakness to strength. Because not all of your arguments are strong, right? There's some parts of your case where you got good law on your side, and other parts of your case where you do not have good law on your side. And there's some parts of the case where you have some good facts, other parts you don't have good facts. And you have to figure how to transition from your not so good parts to your good parts. And that's great. Like I was asking Miss Lewis about, what about a subway? Okay, no, you can do that. What about a college campus? Okay, what about the island of Manhattan? Right? And I'm not making this argument up. If you actually go to the real Supreme Court arguments, that exact question was asked. And when I tell you something, the lawyer for the Supreme Court did not have a good answer. Your answer was as good as his, right? I mean, I'm not exaggerating too much, but the Statute of Northampton, there's a lot of debate of what that meant. You said, nope, here's what Blackstone said. That's a good answer. It's not what you think. It's what William Blackstone wrote 400 years ago. So I'm impressed. Again, you two are solo. That's not easy. I give you a lot more credit for taking this on by yourself. You don't have a partner to lean on, but also you kept your composure. You were smooth. I could tell a couple times, like, oh my God, what's he doing to me? Then you sort of just move on with it, and it's excellent. Reed and Ashley, any comments for our students?
Good job to both of you. I think it's y'all got the real experience, because when you do moot court in law school, you don't have someone standing there next to you. It's just you at the podium, and with 3, sometimes 5, sometimes 9 judges in front. So it's very impressive that y'all can do this at this age.
Yeah, you guys are 16. What are you, 16, 17 years old?
I'm 15.
15, my goodness, 15. How old are you, Ms. Lewis?
Also 15.
Look at this. I got 2 15-year-olds. My goodness. Yeah, I couldn't just when I was 15. Forget it. You could be in law school tomorrow. Forget it. 15, please.
Yeah, no, that's so crazy. Y'all did so good. I know it was way harder doing it by yourself, but I mean, y'all made it look easy, and I think your answers were, well thought out, and I like that y'all cited to a lot of different sources.
Yeah, that's not easy. And you had paragraph this. I mean, that's impressive. I always like to give the teachers a chance to ask any questions. Also, I always like to thank the coaches. I know how hard they have to work. But Mr. Weekly, anything you want to ask us for the tournament?
I don't think so. That was very instructive. Thank you so much for letting me tune in.
Of course. And the students, you have any questions for us? You can grill us and ask us maybe things you don't understand or about law school, whatever you want to ask us. It's fair game.
Well, actually, I do have a question that maybe
Sure,
might
please.
be helpful for them. So I assume that that you all do moot court. Do you have any recommendations on prep for students?
I'll ask Reed and Ashley because they're closer to than I am. What do you
Oh,
guys?
yeah. I do a lot of moot court. What do you mean by prep? I guess let me ask, like, just in how to practice for rounds and stuff.
I think your approach to preparing for rounds as well as practice.
So I do a lot of moot court, and we bring in guest judges. So oftentimes, if you're in the community, hopefully you have a decent amount of attorneys who you can send the particular problem. You can send them your brief, and then set up a practice round where they pepper you with questions, and that's what we do, and several nights a week, and just having them adapt. And whenever they get a question from someone, write down your answer to it, because it's oftentimes the questions will be the same for every round. If there's a big hole in your case, and any attorney who's actually read the issue is going to see the hole. Recording yourself also during those practices, and really making sure you're listening to those ums and the weird pauses and stuff that you might have is really helpful.
Yeah, so I don't do moot court. I did take a class last semester that Reed actually kind of co-taught. And I think the most thing I learned from that is just practicing, because I mean, it's hard getting these random questions thrown at you. So I think just keep practicing and figuring out the answers beforehand. It's the easiest.
I'm gonna add one more to that. Your introduction is super important, and make sure that's smooth. Make sure that's, may it please the court, my name is such and such, and get your 2 points or whatever it is. Make sure that's real smooth. And practice in the shower, practice in the mirror. Just think about it all the time.
Any questions from Aurora or Gabriella? No? All right. Well, thank you so much. I'm very proud of you all. We'll have the scores posted by Monday or so. If the students can please disconnect, the judges will confer for a bit. They'll be in touch.
Thank you.
Yeah.
Take care, everyone.
Thank you.
Thank you so much. All right. That was so hard. I felt so bad that her Zoom wasn't working. Oh, I felt horrible for her.
That was rough.
And she had good material too. She had good stuff. She was well prepared. The second she started talking, I was like, oh no.
Mm-hmm.
And I think Reed, you made a fair point. They're solo. This is how they really do it in law school. There's not with this 2-man stuff.
Yeah.
I definitely see the difference between how hard it is to be solo versus like the other people were relying on their partner. So when they didn't have it, their other partner
Crutch.
just stepped in.
Yeah, no, I'm gonna, if Gabrielle advances to the next round, I'll tell her to do it from school, because it's so unfair. Like I don't want to dock her points just because like she lost like a couple minutes of actual like substance.
Yeah.
All right, let's put some numbers in and then we'll get lunch. I'm actually going to Phoenicia. If any of you, I don't know if you live downtown.
I'm downtown.
Actually,
I'll
do you
go-
live,
I live
Oh,
above
I
the
live in the
flying
Heights.
saucer.
where do you live?
I live in the Heights, so not that close. Like
Okay,
15.
well, I'm gonna walk over to Phoenicia and get some lunch and read if you want to meet me there. If not, you can do it.
Sure,
But no pressure. I should have probably said that before, but I'm hungry. So I'll get some lunch. All right, let's put the scores in. We'll be back at 2.
Okay. Do we just want to grade her the same? Just like assume, like, since we couldn't see her like reading from scripts and all that kind of stuff.
Yeah, give her full credit. I really feel bad because you can tell she was working hard and she didn't lose her composure when she's like, "Can you please read the question?" She didn't get like frustrated. That's not easy. Did you have that read any of your competitions where like there was like Zoom issues?
Oh, yeah. I mean, it happens, and I think we had. I mean, the worst is when the judge has an issue, and the judge can't hear you.
Oh,
So,
that sucks.
yeah.
Yeah, better that we could hear her than whatever. All
Y'all are
right.
back all in person this semester, Reed? No more competition?
I'm doing my next competition online virtually, and then I'm going to Vegas
Ooh.
for a competition at University of Las Vegas. So that should be
Oh, good
fun.
for you.
Fun.
It's a nice campus. It's right near the Strip. It's very
That's
close to
what
Las
they
Vegas.
say.
It's like 5 minutes away from the Las Vegas Strip.
Yeah.
I think it's a little bit harder to grade them when they're solo than when they're together, because
I'm actually putting a thumb on the scale of positive. That's just
Yeah.
the way I'm approaching. But you grade however you want. But if she advances, I'm going to tell her to go to her school to do it. So she has a normal Zoom room because it's really just unfair to have that. All right, I got my grades in. All right, Rita, maybe meet you at Phoenicia like in 10-15 minutes. Is that cool?
That works.
All right, yeah, I like that place.
Yep.
And actually, I promise I'll take you guys out to lunch sometime soon to thank you. But this one just is a quickie because I'm hungry.
okay. And come back around too.
Yeah, like 1:50 we'll be back. All right,
Okay.
I'll see you guys later. Bye-bye.
Yeah.
Bye.